can the U.S. Department of Education require schools to stop all DEI programs and activity? What do they actually mean when they talk about DEI? Jamie, are you ready to go 3 rounds on the Injunction Junction?
Man, being in public education, it sometimes feels like we're kind of stuck in this ring. But bring it on, Chris. Let's go for a 3-fer today.
Ding, ding.
Three cases for the price of one.
Or none, really.
Or none. Yeah, because anybody can listen to this thing.
Yeah? You get what you pay for.
Yeah, exactly. So today we're covering how 3 courts are dealing with the Trump administration's education directives to curtail DEI programs and initiatives in schools. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I'm a former high school English teacher and school attorney. Now we're both professors of educational leadership, exploring the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
Okay, everybody, welcome back to the show. Really quickly, we just want to remind everybody, please rate and review Chalk and Gavel. If you're checking us out on YouTube, please give this video a like and subscribe. That helps us spread the word, get the show out to as many people as possible. We also have a teaching guide on our website, chalkandgavel.com, and we'd love it if you would consider supporting us on Patreon for just $2 a month. It'll really help us keep this show going. That's patreon.com/chalkandgavel. Now, let's get on to our bell ringer. Chris, what's the big update?
Yeah, I've got exciting news. The Supreme Court of the United States has decided the St. Isidore, Oklahoma virtual religious charter school case.
Yeah, so that was the one we covered in episode 44, I think, which is just
recently, yeah. With Martha McCarthy.
Right, yeah, with Martha McCarthy. And actually, we weren't expecting it to be as quick as it did. Like 2 days after we dropped that episode, a decision came out.
Which, thankfully, we dropped the episode before we got the decision.
Yeah.
It was a close call, though, but you're right. And the reason I think they got it out so fast is, are you ready for the opinion?
I was born ready.
That's good. So here's the opinion in its entirety. You ready?
Yes.
Per curiam, the judgment is affirmed by an equally divided court. Justice Barrett took no part in the consideration or discussion of these cases. Full stop. That is the decision in the St. Isidore, Oklahoma virtual religious charter school case. It is a tie.
It's a tie. And that's basically all the decision said is like, you know what? It's a tie. We're done.
Right. And a tie goes to the runner. So the lower court decision stands. So basically, the Oklahoma Supreme Court decision saying that, at least in Oklahoma, it violates the Constitution to have a religious charter school,
which the Oklahoma Supreme Court deemed to be a public entity.
Right, based on Oklahoma law. Yeah.
Yes.
So that has no effect on the rest of the country. And
we can easily see a similar lawsuit come up from somewhere else. We probably will at some point, is my guess.
If another state is, crazy enough to do what Oklahoma's been doing. But yeah, it'll happen. And Justice Barrett may not recuse herself from the next one, right? And so there's speculation.
She recused herself, but didn't necessarily say the exact reason, but it was speculated, right, that because of her ties to...
She had some close personal relationships with people who were involved in the case. That's kind of the speculation that I've heard.
Yeah. So what that does is it takes your 9-member court down to an 8-member court.
Right.
And there's a tie.
Right. 4-4, which means
there was
we got to do some math.
Yeah.
Because we talked about that with Martha, is trying to figure out where the fourth vote is. And Martha expressed some cautious optimism that Justice Roberts, based on some of his questions, Chief Justice Roberts was leaning towards, like, this is where the line is in our cases about like free exercise versus establishment clause concerns. So there's no obvious, like, no one has said how anyone voted, and we won't know that probably until their records become public after they retire. So, it's going to be a minute. But that's kind of the speculation, is it was probably Justice Roberts who voted with the 3 liberals to make it a 4-4 tie. Right. The really interesting thing is, like, a per curiam opinion means that it's the opinion of the court. There's no author here, and no one else wrote any other opinion. So, like, we have no idea why they voted the way they voted or how they would have thought about this case. Like, it is just basically it never happened kind of thing.
Yeah. I guess that's a good way to put it. And, but it definitely does seem like it was Roberts. And one of the reasons is, in addition to the line of questioning that he had, which was basically centering on, this case rested a lot, at least from St. Isidore's perspective, it rested a lot on the previous 3 cases that have come up at the Supreme Court over the last 10 years that dealt with religious institutions' ability to sort of access public
programs and activities,
activities, things like that.
Entitlements, tax credits, stuff like that.
Where the court in those cases kind of went against precedent and prioritized the free exercise clause over the establishment clause. And Martha talked about, I like the way Martha put it, where they have kind of shifted the free exercise clause. Instead of it protecting individual religious liberty, it has now become an entitlement. They're using it sort of as an entitlement.
Right, as a sword rather than a shield.
Yeah, exactly. And in those cases, I think it was Roberts who wrote the opinions
All
in
3,
those
I'm
cases,
pretty sure.
Right? So he wrote the opinion in those cases, and then his line of questioning in the St. Isidore case made us wonder if he was basically, at least the way I interpreted it, was like he was saying, wait a second, you're relying really heavily on the opinions in these 3 cases, but I think there's a line here that you're taking this a little far.
Yeah, he asked the question, I forget exactly how he phrased it, but he basically said, isn't there something fundamentally different about this than those?
Yeah.
And so, I think that's, if I had to put money down, like, that's kind of my guess.
Yeah.
But this is not how I expected it to come down. Let me just say that. I did predict a 4-4. I don't know if you recorded that, Robert, or not.
Well, I think, we all started out when we found out that this case was being taken up by the court, which we were kind of surprised about.
Right, because it's so hard. And I think
hard.
That, like, this 4-4 vote kind of proves just how hard of a case it is.
Yeah. But I think we were, initially back in January when they decided to take this up, there were a lot of us that were going like, uh-oh. They've decided to take this
track record of the free exercise clause versus the establishment clause. Like, the free exercise clause has been doing very well at the court.
Yeah, exactly. And so I think that, there were a lot of us, and I think Martha included, that for a while were like, I think this is going to go in St. Isidore's favor. But once the oral arguments took place and we listened to Robert's line of questioning and even some of the other questions that were being raised by, like, Gorsuch and whatever, I think that, we were starting to kind of say, this might be a little closer than we thought. And sure enough, it was pretty much as close as they can get.
Right. And the fact that no one wrote an opinion, like, I got to imagine that kind of means, like, 2 things. One, they've got too much work and they didn't want to have to, like, write opinions if it wasn't going to matter. Or 2,
or they had to like be separated in that deliberation room because things got so contentious.
Honestly, I think that's probably what it is. Like, you have 8 justices who probably were going to write 8 different opinions because none of them could agree on anything. Like, I think that's probably more likely where, like, it was going to be so contentious and fractious that, like, they're just like, well, let's punt that for another day.
Yeah. Yeah. Well, I'm sure they'll get their chance at some point.
Someone else is going to try it.
Yeah. Well, so there you have it. One of the big major education cases at the Supreme Court this year
turned out not to be so major.
Yeah,
Which
exactly.
there goes our idea of doing an episode on the ultimate opinion.
Yes,
'Cause-
we'll have to find something else to talk about. Do you think that we'll have any?
The way things are going, I think, we'll probably just have to wrap up Chalk and Gavel because there's not really much going on in education law.
Yeah, but chances are we're going to have somewhat of an interesting opinion with the Mahmoud case.
Right. Maybe that'll be our second two-parter.
So yeah, we'll have to see how that goes. All right. Well,
Speaking of interesting developments in education law.
Yeah, there's quite a bit of them. Let's dive into today's case. So we've talked a lot over the last few months about all of the different things that have been happening at the federal level in terms of administrative kind of mandates and stuff that's been happening at the Department of Education and all of the cuts and then the lawsuits. A recent bell ringer we talked about, the 38 plus lawsuits that Ed Week is tracking in a very pretty color-coded kind of article. There's been a lot. And so one of the big things that has come up quite a bit has been the administration's focus on DEI.
Right.
And so we talked about in a bell ringer from, I think it was episode 39 or whatever, we talked about the Dear Colleague letter that was written, that came out by the Department of Education. Right. And we talked about a lot of these things, but we haven't been giving as much attention to sort of the responses, the legal responses.
Right.
Which is what we're going to do today.
Develop, right?
Yeah, exactly. Like, somebody comes out, this Dear Colleague letter comes out, right, and says, hey, you need to focus on this and stop doing that or whatever. And then people are like, whoa, wait a second. We got this is potentially problematic. And then they start lawsuits and things like that. So today, what we're going to do is we're going to talk about this Dear Colleague letter, and we're going to talk about the 3 lawsuits that are sort of playing out in response to this Dear Colleague letter. Okay. So first of all, Chris, what is a Dear Colleague letter?
I thought you'd never ask. Right. So
it's in my notes here. It says, ask Chris, what's a Dear?
Well, go check out, what is it? Episode 18, I think, where we talked about the new Title IX regs. We kind of dig into the different ways that executive agencies can basically change policy, right?
Right.
And so a Dear Colleague letter is an informal guidance document. And the thing that differentiates a Dear Colleague letter from a regulation is, well, there's a couple things. One is a Dear Colleague letter is not supposed to create new legal rights or obligations. It's basically just the department saying, here's how we understand existing law, or, here's how it applies to a new situation. Regulations, on the other hand, do create new legal obligations. So, they change how you follow the law. And, there's a blurry line between those two things sometimes. And, the consequence of those differences is basically, if you aren't creating new legal obligations, you don't have to go through much of a formal process. You can basically just issue a Dear Colleague letter. If you are changing kind of legal obligations or, changing the rules that people have to follow, you have to go through a really long, drawn out notice and comment procedure.
Yeah.
And that takes years. We talked about with the Title IX, like the new Title IX regs took years to go. And then, they immediately got challenged, right?
Yeah.
To our point about these lawsuits being a natural part of the cycle.
Right.
And so like the Dear Colleague letter is basically the department saying like, here's what we think the law means, but that doesn't change anything. It just lets you know what we're going to be thinking about when we're looking at these things.
Yeah. So I guess if you're considering sort of the hierarchy of, I guess, the weight of directives, this is pretty low on the list, right? Like, you got the Constitution, right? Like that's the
supreme law of the land.
That's the supreme law of the land, right? And then you've got the laws and regulations that are created by legislatures and things like that. They go through, like you said, they go through this huge process. And oftentimes they're somewhat detailed and sometimes they're not. And I think one of the reasons why you see a lot of Title IX Dear Colleague letters is because Title IX is one of those things that is not necessarily incredibly detailed, right? So it's a very short clause. And so what happens is a lot of questions about how to enact or be in compliance with a law or regulation, a lot of questions often come up. We're talking on this podcast about K-12 schools. So oftentimes a lot of questions will come up and say, well, this is how we do things in schools, or we want to do something in schools this way, but I have no idea how that is affected by the law or how this is going to affect all of that stuff. And so the Dear Colleague letter is supposed to be an opportunity for the people in the Department of Education to say, all right, here's what we think. Right?
Yeah. Another way that I've heard them described is Dear Colleague letters are safe harbors, where basically they don't tell you what to do, but they tell you where you'll be safe from enforcement actions.
Yeah.
So they don't define what the law is, but they tell you here is the safe harbor. Here's the safe zone where if you do this, you're not going to violate the law. That isn't to say though, that if you don't do this, you are violating the law.
Exactly. Here's where we're going to put our sort of investigatory energy.
Mm-hmm. Right. Yeah. And I think that distinction might have gotten this Dear Colleague letter into trouble.
Yeah. So let's talk about this Dear Colleague letter a little bit and these 3 cases. So the Dear Colleague letter that we talked about in episode 39 that came out from the Trump administration, it purported to, quote, reiterate existing legal requirements, unquote, under Title VI of the Civil Rights Act. Okay? So this Dear Colleague letter is basically saying, we're just reiterating what Title VI of the Civil Rights Act requires of all of us. So it's kind of, it's basically claiming we're not, this is nothing big. This is nothing new. This is already the law of the land. Title VI is the law of the land. But
we just wanted to send you a friendly reminder.
Yeah, friendly reminder, right? It's been challenged 3 times.
There's just been 3 decisions. 3
cases. Okay. They're all pretty much challenging the same thing, but because each was filed from a different court by different plaintiffs, that's why we've got 3 lawsuits. So even though they're all attacking sort of the same thing, that's why there's 3 of them. One of them is in DC, one's in New Hampshire, one's in Maryland, filed by the NAACP, the AFT, the American Sociological Association, the Eugene, Oregon School District, the NEA, National Education Association, the Center for Black Educator Development. A lot of people have signed on to these.
Here, so in the department.
Yes.
Right. And the AFT and NEA, those are the 2 biggest teacher unions.
Teacher unions. Right. Yeah. Exactly. So there's a lot of backing to these lawsuits. So let's dig into this stuff, this Dear Colleague letter. So on February 14th, Valentine's Day.
Yeah, I would have published it on a different day.
Well,
thinking about the optics.
Yeah. So they issued this Dear Colleague letter on Valentine's Day. So I guess it was a Dear Colleague love letter, right?
No. Okay. Maybe.
So here's what it did. It directed all federally funded educational institutions, so then, all K-12, whatever, and higher ed too, and to cease all racially discriminatory initiatives and unlawful DEI programs, including in admissions, financial aid, hiring, training, classroom instruction. Basically, it said, stop all race discrimination and unlawful DEI programs.
Right. And already there's some big red flags because stop doing unlawful stuff. Okay. You don't need a Dear Colleague letter for that.
No. Right? Stop breaking the law.
Oh, thank you.
Oh,
I didn't realize.
Oh, I had forgotten that was a responsibility.
But
don't discriminate based on race.
Oh,
okay.
Right. Yeah. So there's already something problematic here. And then there's the conflation of basically we're adding adjectives in front of DEI programs and then we're conspicuously dropping them later so that basically unlawful DEI programs become synonymous with
DEI programs.
DEI programs. Exactly. Yeah. And that's kind of what's happening here is look, we understand intentional racial discrimination to mean anytime you think about race. Therefore, all DEI programs are intentional discrimination.
Yeah. And that is getting problematic and messy, which is essentially what these lawsuits are saying. So while this Dear Colleague letter is essentially just being framed as a reminder of our obligation to not break the law, like you mentioned, these things are getting conflated. Okay.
Right.
So don't do any unlawful DEI stuff. okay, like if it's unlawful, we shouldn't be doing it. It doesn't matter what it is. If it breaks the law, we probably shouldn't be doing it. But, like you said, they're dropping that unlawful and they're just basically saying, if it is DEI, it is unlawful because you are thinking about race and that's discrimination. And the letter basically asserts that educational institutions have been breaking the law by engaging in racially discriminatory practices that are sort of disguised as diversity, equity, and inclusion.
Right. Yeah. And so it's this really interesting, like, rhetorical device that they're using, basically saying, like, some DEI initiatives are racially discriminatory, but then they say, therefore, DEI initiatives are unlawful. Right. And so you can see how, like, the part becomes the whole, right? Mm-hmm. And so that's kind of what the letter is doing. And I think that's where, it's vague, right? And that's a huge problem about this letter, but it's also, like we talked about earlier, like blurring that line between I'm telling you what the law is versus I'm making new law.
Yeah, exactly. And so, speaking of vague, like one of the things that we have been wrestling with over the last number of months in education is, anybody in education right now is well aware of what we're talking about, well aware of this push to end anything that is sort of associated with DEI or whatever. And so this, this shouldn't come as news to anybody who works in or near any education circles.
Oh, lately. Yeah.
But one of the things that comes up constantly in these conversations is, okay, we're talking about DEI. What specifically is meant by that?
Yeah.
Right.
Like,
stop your DEI
under that umbrella.
Yeah. Stop your DEI programs. Okay. What exactly do you want me to be looking for? Okay?
That is completely absent from any of this. Like the Dear Colleague letter and then the other implementation documents, like there's never been, at least that I'm aware of from the Trump administration, any kind of like definition of what they mean by DEI other than, by DEI, we mean unlawful discriminatory practices. And that, that like says, okay, like, well, Title VI says you can't do unlawful things. And like, or what's the thing? It puts the definition in the definition.
Yeah.
Right.
Yeah.
Or puts the term in the definition. There it is.
Right. Yeah. And, and so that's problematic because there are so many things out there, right? That I'm thinking about, we did that episode on I think it was the Fairfax County,
Thomas Jefferson,
the TJ Coalition for TJ, about the admissions practices. And one of the things we talked about in that episode was what magnet schools are, right? And how magnet schools are kind of designed to better capture a community's diverse nature, right? And bring kids from different areas, hence the term magnet, right? So,
right.
So
is that a DEI initiative, right?
Like, it sounds like it would be under their vague definition of this, because what we're trying to do is bring in people from different places.
Right. And you'll also remember in that case, we talked about how the people challenging kind of the changes in the enrollment policies were making the argument that, like, because you knew about race and because you were acting to promote diversity, and racial diversity is, obviously a part of diversity, like you were intentionally discriminating based on race. So again, it was conflating that idea of like awareness of race is inherently discriminatory.
Yeah. And I think, one of the big differences here that, that we should talk about a little bit is, that for a long time, the courts have recognized this sort of difference between an acknowledgement of race, an understanding of
the social
diversity.
Context of race. Yeah.
Yeah. Like there are people of different races and things affect different people differently.
Right. And there are societal inequalities.
Right. And we have to be, and it's okay to be aware of that, as long as you are not actively discriminating against a particular group or trying to favor one group over another.
Right.
It's okay to acknowledge that there are differences out there.
Right. As long as you're not intending to create a different impact based on race, right? Like,
right.
Yeah.
Right.
And that's the line that the courts have historically drawn.
Right. But then the Students for Fair Admissions case comes along and they're basically saying, you know what? We're gonna move where that line is.
Right. And that's
Right.
what this Dear Colleague letter also does.
Yeah.
Right.
Exactly.
And the other interesting thing is this is a 180 from prior Dear Colleague letters. So prior Dear Colleague letters had said essentially like, hey, DEI programs are a great way to promote socioeconomic diversity because they are race conscious, but they're not racially discriminatory. And
Yeah.
so after, like in 2023, after the Harvard affirmative action case, which, struck down affirmative action in higher ed, the Biden administration put out a Dear Colleague letter that said like, look, yeah, you can't do that, but here's what you can do if you're still wanting to pursue the compelling governmental interest in diversity, or if you're still interested in pursuing diversity.
Yeah. Yeah.
So
exactly.
this is a change of tune, if you will.
So let's quickly walk through the timeline of how all this went down. So we've got this Dear Colleague letter. It comes out on February 14th.
Not only did it come out on February 14th, it gave schools 14 days to come into compliance.
Yeah, yeah. That I would say that it's not necessarily all that uncommon for the government to come out and say, here's how we're going to be approaching things. You have 2 weeks to comply. Like that has happened on a few occasions with Title IX regulations and Dear Colleague letters, goes through the whole process and all that stuff. And it comes out in July and they're like, hey, the school year's starting in August.
Good luck.
Have a good time, right? Make sure that you're in compliance. So that's not necessarily all that uncommon.
Right.
It's annoying.
But the 2 weeks kind of, I guess, highlights that this isn't just a reminder to keep doing what you're doing. Right.
Yeah, right. Like we're
really short.
We're going to deal with this.
Yeah.
And here's how they decided to deal with this. So on February 27th, the department issued a press release that announcing the creation of a website called nDEI.ed.gov. So a government website called nDEI. And that was supposed to be a portal to submit reports of discrimination based on race and sex in K-12 schools, and the department would use that as a guide to identify potential areas for investigation. Okay. So basically saying, hey, public, anything that you think is violating, our stance on DEI, go ahead and let us know and we'll start investigating.
Yeah, the URL for that, I think, says the quiet part out loud, though I guess it's not even the quiet part. Like they called it nDEI.
Yeah.
Right.
Yeah.
So again, going back to our conversation about okay, well, don't do unlawful DEI. Now it's just
nDEI.
Yeah. So
they could have said, report racial and sexual discrimination.
That's a terrible URL, dude.
I don't
hey, endracism.ed.gov. Cool.
Yeah. Okay.
Awesome.
That's
right.
better.
Enddiscrimination.ed.gov.
Yeah. I can get on board with that.
Right.
So the next day, February 28th, exactly 2 weeks after the Dear Colleague letter, one day after this announcement about nDEI.gov, they probably got some questions from schools after that announcement came out.
Yeah, schools were concerned. Yeah, that's the word I want.
That's a word. So the department issued this FAQ document.
Right. And if we're going on, let's say, layers of authority, let's say an FAQ is below a Dear Colleague letter.
Yeah. So the FAQ stated that schools are prohibited from creating racially hostile environments and from supporting, quote, any other aspect of school life that allows one race but not another. Okay. So the first part, creating a racially hostile environment, is bad. Okay. I'm good.
Right. And that statement, by itself is pretty, uncontroversial, I would say.
Yeah.
Hey, you can't create a racially hostile environment. That's part of Title VI, just like you can't create a sexually hostile environment under Title IX. And, we don't want to separate people based on race. That's what Brown versus Board of Education was all about, 1954.
Right. Or we don't want to allow one racial group to have access to something that another racial group, and one thing that goes through my mind is the Equal Access Act, right?
Yeah.
So one of the questions in the FAQ was whether or not DEI programs are indeed unlawful. And here is part of the answer that it gives.
Right. Which that is the question.
Yeah, that's, are DEI programs unlawful? And here's the answer. Schools may not operate policies or programs under any name that intentionally treat students differently based on race, engage in racial stereotyping, or create hostile environments for students of particular races.
Okay. And again, pretty uncontroversial until we try to define what those terms mean, I imagine.
Yeah.
So what do we mean by intentionally treating students different? We already kind of talked about that, how they are conflating awareness and intent. And then racial stereotyping, I'm not sure what that means, exactly. But I think that creating hostile environments one is really, really tricky.
Yeah. Well, and also treating students differently is, that to me is very interesting. One of the things I think about is there has been a long-standing conversation about discriminatory discipline practices.
Right.
In schools, right? And there's a lot of data out there that indicates that discipline is being disproportionately applied to certain racial groups, And so there's a lot of energy in many places directed at looking at that data and modifying practices.
Disproportionality, yeah.
Yeah. And under these definitions,
efforts to reduce disproportionality would be intentional race discrimination.
Exactly.
Because you're
trying to end race discrimination.
Right. And that's actually kind of there's been some movement in the Trump administration on school discipline. Yeah. And that, is kind of what they're starting to go for. And this kind of comes about after a lot of what President Obama did on racial disproportionality in school discipline. But you've got these race neutral policy changes to make it so that we rely less on disproportional or on exclusionary discipline. So restorative justice. That has nothing to do with race, but, the argument is that okay, well, you implemented that to address societal inequalities. Therefore, you were motivated by race, and that is unlawful discrimination. So we need to that. And I think that they would say that is unlawful DEI.
Right.
And that kind of just shows you as an example of how this train of thought goes. And if you follow that train of thought, it kind of shows that this Dear Colleague letter in FAQ, they do a lot more than just say what the law is.
Yeah. Yeah. In this particular case that we're kind of talking about right now, it's almost like saying efforts to reduce discrimination are discriminatory.
Right. Yeah. And we talked about that with the TJ case. It basically enshrines the status quo into a constitutionally protected status or a legally protected status, because if you are aware of existing racial disparities, you can't address those racial disparities even in non-race neutral ways, because under this, that is race discrimination.
Yeah. So just a couple other things from this FAQ. They give examples of what could be potentially unlawful DEI practices. One of the things they talk about is social emotional learning programs.
Which I never understood that connection, but maybe it goes back to what we were talking about, trying to address the need for exclusionary discipline and things like that.
Yeah. And I think part of the thing here is that a lot of systems and programs affect people differently. Right?
And that's kind of the point, because the point is that different people have different access and recognition and outcomes within our systems of education.
Yeah. And it's not just a racial thing. There's sex and gender and socioeconomic status and all kinds of things that classify people into different sort of categories. Those categories are impacted by the system and the programs in different ways. And so there's a lot of stuff that has come up in response to that, to try to address that and to try to account for that and consider that. So, but this FAQ identifies social emotional learning as a potential unlawful thing.
Under Title VI, right? Yeah. Same thing with
culturally responsive teaching practices and stuff like that. All of that is considered kind of unlawful in there. And basically, after this FAQ came out, dozens and dozens of Title VI investigations have popped up at the department.
Right. And based on the Dear Colleague letter and the FAQ, right?
And the FAQ.
So it is already being enforced. I think a lot of those are at the higher ed level, but
yeah. And then in April, the department issues a certification requirement that mandates that state educational agencies and schools have to certify by the end of April that they're in compliance with the Dear Colleague letter. And if they don't do that, they're going to lose federal funding.
Right. And there were other consequences too. If you failed to do that, or if they found that you had lied, essentially like it created legal liability in some interesting ways. So like there were real consequences if you didn't abide by the certification requirement.
Yeah. And so I think, if you've been in schools or around schools in the last few months, like that sort of pressure is real, right? This is not just all taking place in the courts. This is not just all taking place at a policy level. Like this has trickled down very, very fast, and it has had some very, very intense practical impacts in the last few months. Okay. Except 3 things have come up. And what happened with those 3 things?
Well, since we're talking about it, as you probably guessed, some educational folks took issue with these agency actions, and they filed a number of lawsuits. We've already kind of talked about all the different players. We've got the teacher unions, we've got a school district, we've got the NAACP, all challenging these actions in 3 different courts. And interestingly enough, all of them are asking for a preliminary injunction. We've talked about PIs in the past, but basically it's the pause button. We think you're violating the law. We want you to stop violating the law while we're doing this litigation.
The legal stuff. Yeah. While this all plays out and while we wrestle with these questions, basically what it's saying is there is potential harm being done. We think there's potential harm being done enough so that you got to stop doing this while we figure this out.
Yeah. Because if you allowed it to do it, like you're not going to be able to fix that after the fact.
Right.
So in each of the 3 cases, they're asking for a preliminary injunction, and drum roll, in all 3 cases, the plaintiffs win at least part of their argument. So each of the 3 courts, for different reasons, issued an injunction, all of them on April 24th, interestingly enough, which stops enforcement of the Dear Colleague letter.
Do you think they were like texting each other? Hey, what are you going to do?
Like, right. Yeah. Like, hey, are you going to, which way are you going? I doubt it. I think it's more that the certification requirement was due
April
by
24th.
Yeah, so they're like, I'm on a deadline.
Yeah.
But all 3 of these courts issue orders enjoining different parts of the Dear Colleague letter and the implementation of the Dear Colleague letter and the certification requirements.
Right.
And so before digging into the legal reasoning, I think it's really interesting to look at the 3 judges who issued these injunctions.
Okay.
So first, we've got the judge in the NEA case was appointed by President Obama.
Okay.
So, that's usually kind of what we use for like a proxy of political leanings. The judge in the AFT case was nominated by President Obama initially, but that nomination expired without Senate acting on it.
Okay.
And so she was then re-nominated by President Trump during his first term, and that appointment went through.
Oh, interesting.
So like she's kind of like a dual appointee,
double appointee.
Yeah. But it was, she is a Trump appointee.
Yes.
And then the last judge in the NAACP case was appointed by President Trump during his first term. So we've got kind of like an interesting spectrum here of judges. And the NAACP case is the one that had like kind of the most narrow injunction. It only enjoined the certification requirement.
Okay.
But the AFT and the NEA case, like they stopped the whole thing.
Oh.
So I wanted to highlight that this isn't necessarily a red or blue thing because of what we're going to talk about.
Yeah.
So there's 3 kind of big arguments that they're making. The Dear Colleague letter violates the First Amendment because it is denying people their right to receive information. It's viewpoint discriminatory. It's content discriminatory. It's violating academic freedom. All of those First Amendment arguments. And then there are also arguments that under the Fifth Amendment's due process clause, that this is just unconstitutionally vague. It's void for vagueness because we don't know what it is we're not supposed to be doing.
Right.
And then the last argument they're making is that all of this wasn't done the way it was supposed to be done. Basically, you agency didn't do what you were supposed to do to create new rules.
Right.
And for at least the NEA and the AFT courts, they agree with all of those arguments.
That's interesting.
Yeah. The NAACP court, the Trump appointee, found some issues with standing about like whether or not the NAACP was the right people to bring a lawsuit. And so that court didn't reach a lot of these issues. But with kind of digging into the law here, the First Amendment concerns are about viewpoint discrimination, right? Basically, you can talk about race in certain ways, but you can't talk about it in other ways. And that's what these Dear Colleagues letters do, because they weren't just limited to programs or activities. They also addressed curriculum and content and speech, right? And so that was kind of, the AFT court said, like, look, that's clear content-based discrimination. It singles out unfavorable speech regarding systemic and structural racism without any kind of justification.
Right.
And, the government tried to argue that they were regulating conduct. So like discrimination, that's not necessarily speech, but the courts kind of found that stretches just a little bit too far.
Yeah. Yeah. No, that makes sense. So, I'm also really fascinated about this vagueness thing, because that's been what we've all kind of been wrestling with in trying to figure out how to be in compliance with some of these mandates and initiatives and things like that. And one of the things we've always been talking about is, what do they mean? This feels very vague to me, and we need some specifics here. What did the court say on that?
Right. And that, to me, that's the, maybe not the strongest argument, but it's the most clear cut of all of these.
Yeah.
Because the law says under the Due Process Clause that a law is impermissibly vague if it does not provide fair notice of the conduct that is prohibited, or if it allows for or encourages arbitrary enforcement. So basically, if it doesn't give a person notice of what it is they can and can't do, or it doesn't tell the people enforcing the law how to enforce the law clearly enough that they're not just making it up as they go,
right,
that's a problem.
Right.
And, this is especially a concern when we're talking about speech because of the chilling effect that vague laws have. The NEA court actually had a great quote from Justice Thurgood Marshall on this point. Thurgood Marshall said that, quote, vague laws hang over citizens' heads like a sword of Damocles. For the value of a sword of Damocles is that it hangs, not that it drops. And I think that captures this so perfectly. The chilling effect is the looming threat in the background. And because of the extreme consequences here, no one's going to try to, explore where those gray areas are. So the
for
more
fear
vague
of that
law there
thing
is,
coming down. Yeah.
Right. Yeah. It's a massive sword of Damocles. We've got a lot of vagueness here. So people are going to stay as far away from questionable content as they can, even if they're fine. If that would be within the law, they're going to take the kind of the safest route and just avoid all of this altogether.
Yeah. Yeah.
And so, that's kind of the concern here. And the NEA and AFT courts say, that's a real concern because these laws are incredibly vague. They don't define what they mean by DEI programs. And even when they tried to define what they mean by DEI programs in the FAQ, they actually expanded their definition of what they meant by DEI programs. So it didn't reduce ambiguity, actually created more ambiguity.
Yeah, exactly.
And so that is, a big problem. And the government tries to argue no, we said you can't do unlawful things, and unlawful things are intentional discrimination. That's what the law says. And the courts look at that and say but that's not actually what you said, because, the best example of that is you've got a website called enddei.ed.gov. If you were just focused on intentional discrimination, you probably would have come up with a different name.
Yeah. Basically, the courts are kind of saying what we've said before is if you are just concerned with ending unlawful discrimination, then why are you replacing that term with DEI? You're are saying that all of that is unlawful.
Right. And you don't tell us what you mean by that, other than to say DEI is unlawful. And
because it's, and
DEI
how do we know?
Is unlawful discrimination, right? So it's is that a tautology?
What exactly is unlawful? And their response is, well, the unlawful
discrimination.
Stuff. Yeah.
You're right. Yeah. And then the last legal argument is the process argument under the APA. And this gets into the weeds on administrative law, which is probably not something our audience is as into. But, as someone who sat in the front row of my law school administrative law class because I got there late on the first day and he assigned seats. I know admin law very well, but the APA basically lays out how agencies can create and enforce legal obligations. And so this all kind of hinges on whether it's creating new legal obligations. And for at least the NEA and AFT court, this Dear Colleague letter is creating new legal obligations because it is not just telling you what the law is, it is creating new law.
Yes.
And because of that, there are a ton of rules that the APA says that the agency should have followed in putting this out.
Yeah, exactly.
Like you had to go through notice and comment period. And then there's also like a bunch of other stuff that the APA says, like you can't have a rule that is contrary to constitutional rights or existing law. We've already talked about that. Like this is both. And it also is beyond the agency's authority, which is another thing that the APA asks, because interestingly, federal law says that the DOE cannot exercise control over the curriculum. And this is saying that you can't put certain things in the curriculum. So like that's another check, it's beyond the agency's authority. It contradicts existing constitutional rights or
it also contradicts a lot of what the administration sort of has been focused on,
right?
About how their efforts are aimed at moving as much control back to the states as possible.
Right. And we talked about that too when we talked about like the order ostensibly directing the closure of the Department of Education. It's like,
right.
Which direction are we going?
Yeah,
here?
exactly.
And it's a 180, right? Like,
yes,
we had interpreted Title VI in one way to say like, hey, DEI is actually a great way to accomplish your goals of increasing diversity or reducing inequalities.
Yes.
Now we're saying, oh, just kidding.
DEI.
It's itself unlawful.
Yeah, exactly.
And so, because of all of that, like clearly this violates the APA, like it should have gone through a different process, but the notice and comment process takes years and, who's got time for that?
Exactly. Well, that's one of the reasons why we waited so long for those updated Title IX regs that the Biden administration put out, is because they went through that whole process, the notice and comment period.
Anyway, but
and they got struck down.
Well, we're still waiting to see the ultimate consequence of that.
Yes.
But, the bottom line from all three of these cases is that the DEI Dear Colleague letter and its implementation are on hold. So, there's been a lot of concerns about these orders and a lot of, doomsaying about their impact. But based on these lawsuits, those no longer have the force or effect of law.
Of the Department of Education at the federal level. All right. So states can be doing their own stuff.
Well, and there's other stuff going on, about all of this as well. But, at least this set of things are on hold. And if you actually go to the DOE's website and find the Dear Colleague letter, it's still up there. But at the top in red text, it says, quote, the Department of Education's Office for Civil Rights will not take any enforcement action or otherwise implement the Dear Colleague letter, the associated FAQ, the NDEI portal, or the certification requirement until further notice because of these court cases.
Yeah. So the big takeaways here are, at least at the federal level, that's all on hold. Okay.
Right.
And this stuff is going to play out in the courts, and they're going to, all of the reasoning that Chris just talked about is going to be sort of wrestled with, evaluated, analyzed, or whatever in the courts. And eventually the courts will make a decision one way or another as to the lawfulness, I guess, of the Dear Colleague letter and these initiatives from the Department of Education around DEI. But until then, nothing's happening.
Keep listening to Chalk and Gavel, because we talked about this, when it first came out, we expressed some skepticism, right?
Exactly.
And now, a little bit of validation.
Yeah.
But to me, one of the big takeaways here is the challenge of the challenge of the justice system that we've got. Like, it is so hard to guess which way things are going to go when they're happening in a way that allows you to realize your educational goals while also ensuring legal compliance. And that that's kind of part of what we've seen the Trump administration do, is they've flooded the zone with all of these different things so that everyone's just kind of scrambling to catch up, which means that, we don't have time to kind of really unpack and to make nuanced distinctions. And so
yeah, it's hard to see the forest for the trees if if you're in it, right? And you've got no way to kind of step out.
Right. Yeah.
And evaluate.
To kind of use two metaphors, you can't unring that bell, right? Like, this letter came out, it rang a bell, people scrambled. And now we've got these injunctions that are basically trying to unring that bell, basically saying you never should have rung the bell in the first place.
Yeah.
Yeah. I was also going to say a lie will make it around the world before the truth has time to put on its shoes.
Oh, yeah.
Right.
Yeah.
this Dear Colleague letter made it around the world, and now these injunctions are just now putting on their shoes.
Yes, exactly. And, I think there's anything that you've taken away from Chalk and Gavel, it's that the legal system is not the most expedient.
It's deliberate.
Entity.
Let's say that.
Yes, and that can be a very frustrating thing, but it can also be a very helpful
Right.
feature.
It's a necessary thing, really, but
it's not necessarily a bug. It's right.
And that kind of emphasizes something that Jamie, you and I have talked about and are really passionate about, like the need for legal literacy, because you get these things, you got to know enough about the law to know what to do with them.
Right. Because you can't rely on the law to answer every single one of your questions.
Right.
Because nobody has that time and nobody has.
I don't have a crystal ball, right?
Exactly.
So that knowing the law, knowing how to interpret the law, knowing the existing state of the law, and then, knowing how to work within the law to do what you need to do to not get in trouble with the law, but also do what you need to do to kind of do what you think is best for kids and for your schools, right? And that I think it's tough, but I think it's so necessary. And this is just a great example of why that's necessary.
Yeah. And I think, you've got a lot of organizations like the NEA, whatever, who, when this Dear Colleague letter came out, they're like, okay, we want to be in compliance with the law, whatever the law is. So we've got lots of questions for you because essentially we're legally literate enough to know that we don't know how to interpret this. We don't know how to deal with this. So they ask a whole bunch of questions. They get a whole bunch of responses that really don't do much to clear anything up.
Or compound the problem.
Or makes things worse. And now we've got, and then their response is like, you know what? This is not good enough. I don't feel like this is making things easier, more clear, or appropriate in terms of our educational goals and mission, whatever. So we're going to challenge this. We're going to keep you posted, of course, as all of this stuff plays out. This and the other 38 some odd lawsuits, at least at the time of this recording.
Yeah. And you know what? It makes me think of A Christmas Story. The prize for collecting your Ovaltine things and mailing in for your decoder ring
is a
message to drink more Ovaltine.
Yeah, that's right.
Chalk and Gavel. Your reward for listening to Chalk and Gavel is...
That's right. Man, I remember that.
Listen to more Chalk and Gavel. Maybe that's your homework. Yeah, that's your homework. Let's do it. Your homework is to drink more Ovaltine and listen to more Chalk and Gavel.
Do they still even make Ovaltine?
We looked this up when we did the Red Ryder BB gun
that's
episode.
Right. We did. We did.
They do.
So now we have 2 episodes that reference a Christmas story.
Yeah.
Okay.
Yeah,
this episode is dropping, I don't know, in June, July. So it's Christmas.
I think is when the last one dropped. I think we did Christmas in June or July last time too.
I would like to say it's all intentional, folks. It's all part
everything
of the plan,
we do on the show is very well planned and executed.
All right, Chris, let's do the homework.
Yeah. So like, rate, and review Chalk and Gavel. You can get us everywhere you get your podcasts. Please share the word about the show. If you could leave comments, notes, or whatever it might be. You can find us on YouTube. We're doing a video podcast now. Yeah. Find us on Patreon, patreon.com/Chalk and Gavel. We've got a teaching guide if you want to assign Chalk and Gavel to your classes or for professional development. Everything you need is right there.
Sounds great. Okay, well, that does it for today's episode. So we'll see you back here in 2 weeks with another episode of Chalk and Gavel.